My lord, with a fervent prayer for listing of a matter, my lord. It was first listed on 8 February 2023.
What is the stage?
Says, my lord, notices were issued. My lord, the person is returning on November. But is sought issue to be determined by a lord.
Admission stage?
Yes.
After which year?
23. But he's returning on November, my lord. Difficult after that.
21.
Pardon, my lord.
21.
16th.
The last
Any day, your lord, my lord, in the next.
next week, 16, 17, 18, 19. Do we have a visit on the 6th?
Pardon?
6th of November?
He'll be retiring on that day, my lord.
Not help to come out here.
My lord, I have given
When is he retiring?
13th of November,
6th, we have the 6th reopening day.
my lord.
May I please? So, with the consent of other party, my lord, I beg to mention item number 11. In this case, already I have sent the affidavit in opposition. It is verified. We have to file affidavit in opposition in 1 week time.
My lord, that's an interim order, my lord.
On the prayer of the ticket of is adjourned by which to enable filing of affidavit, which has been paid almost ready. Interim order passed. Then extended. Yes.
Obliged.
May I beg to mention item number 3 of Honorable Justice Romitra Soikas. Item number 3, there is a big matter.
What do you want?
I want the matter to be fixed on if this week, then
If the record comes, you can pass the order. Records are not. Item number 21. Friday next?
my Thursday. It is a
Thursday.
admission. Admission.
Matter
The
of
small issue is, my
which
lord.
year? Which year?
My lord. The
Matter of which
matter
year?
pertaining to 19, my lord.
2019.
My lord.
Then it comes here for the petition. Mr. Patel.
My lord, I am for the petition. Obliged.
My lord, I have a prayer in respect of item number 12. My lord. Item number 12 today, my lord. The
Yes.
matter is for hearing. This is a section 11 petition, my lord. This involves, my lord, some issues relating to third-party rights in arbitration, my lord. So,
Item
matter
number
takes,
12.
my lord, it will take some time, my lord, and therefore I seek some accommodation. Can it be after vacation, my lord?
Why not?
My lord, some constraints are there, my lord, today. This will take some time, my lord.
The time we have all the time.
My lord, I understand.
Okay, another matter is.
Is there any analogous matter?
No,
No.
I am.
My lord, probably he is also constrained for time today, my lord.
Okay, on our joint prayer made on behalf of party. Matter is adjourned.
I beg to mention item number 8, my lord. I have filed a reasonable affidavit on Saturday matter.
May I please? Lord, I pray for listing of a writ petition for admission. My lord, this matter relates to termination of service, and now a notice was issued, and there is observation to consider the interim as and when the situation arises. Now the authorities are contemplating to, my lord, appoint a new person.
Matter of which year?
22.
21.
Thursday is possible. Thursday or Friday. Friday.
May please. First of all, I beg to mention for listing cost, for orders cost, for matter of 2023.
2020.
23.
Why orders? Why out of turn?
Actually, lordship service has already been completed, but the matter has not been.
So why out of turn listing? Mention is out of turn listing. Why?
Lordship, actually, the petitioners are laboratory technician, and
You're not on the fact. Is there any urgency that you have to mention the matter for listing?
Lord, I beg to mention, my lord,
The matter is old pending my lord of 2017 my lord, and is what last listed on
Okay.
27 of.
What is the stage of the matter?
My lord, read against statutory appeal my lord.
What is the stage?
My lord, it is an order. It will come in order stage
You will have 17 matter
my lord.
on Friday.
My lord. And another matter obliged my lord. My lord, another matter it is against irregularity in appointment my lord. So it is last listed on
Which
13
year?
of-
Matter which year?
of this year my lord.
My lord, I beg to mention this
Obliged.
matter for listing, my lord. My lord, in this case, due to want of.
Matter which year?
Matter of 2022, my lord.
22. What are this?
Urgency, my lord, due to want of police verification, my lord. My salary is dropped, my lord. However, they filed affidavit saying that verification is cleared. And on that day, my lord, Standing Council of Karbi Anglong Autonomous Council was not there, my lord. Matter is very urgent, my lord. My salary is
There is since how many months you have not been?
1.5 years. This is the filing
and a
of
half
this
years.
writ
We
petition.
will have it on Friday. Friday.
Right, obliged.
Lordship, I beg to mention item number 11 and 12 from court number 13. Lordship, the matter is from regard 2016 matter, Lordship. In hearing column, Lordship. The matter is going on the way of disposal, Lordship. So date may be fixed, Lordship.
Whenever 21.
21/11,
20
1/11
of November.
November.
These matters are of year
12 matter, 16 matter, Lordship.
2016. Both 2016.
One 2016 contempt is on 2018.
So both are connected.
Connected matter.
These are all pending. And I mentioned it for looking at it as bench hard not as a considering paper. Command and as
21/11, Lordship. Deeply applied.
May I please, Lord? Lordship, I beg to mention for listing of a case, Lord, newly filed.
motion matter
Yes, motion.
is 21. Tomorrow.
Yes, your Lordship, convenient.
Whenever have you filed or not?
Lordship, I have filed on 6/10/2023, Lord.
Whenever tomorrow or Friday.
Lordship, filed. Highly approved.
Lordship, I pray for listing of an urgent matter, Lordship. It is a writ petition. It was last listed on 8/9/2023. It was supposed to be listed after 2 weeks, and
Matter is which year?
2022, but the petitioner is going to retire in the month of November.
What is the matter about?
Lordship, regarding promotion, Lordship.
On Friday.
Friday.
Yes.
Obliged, Lordship.
Lordship, I beg to mention for listing. Lordship, it's newly filing. Lordship, it was filed on 6/10/20.
Motion matter.
Yes, Lordship.
Whenever you want.
Lordship, before vacation.
Yes, tomorrow or Friday. When motion we can adopt. Give the date whenever you want.
Lordship.
May I please, Lord? My lord, I beg to mention for listing of a motion matter. Day after tomorrow.
They have not on Thursday. Have it on Friday.
Obliged.
Lordship, item number 1, my senior has another hearing matter on court number 17. That one also item number 1. So kindly, if possible, pass over the matter for the time being or for the day.
No, it's a 12 matter. We'll pass over for time. Let him come.
Okay, fix it to me, my lord.
After some time, whenever he comes to take. Who is your senior?
R.K. Malakar.
Let him come. After that matter is over. That's it. Motion. Yes, but
So, my lord, the petitioner, my lord, he appeared for the competitive examination for the post of assistant engineer civil under the joint cadre of public
Yes.
works roads. My lord, and then the official answers keys were released, and on going through the official answers key, the petitioner, as per his calculation, he had scored 128.5. And when the result came out, calling for the viva voce, he found that the candidates scoring much lower than him have been called. For instance, he have stated in his petition that roll number 61458 and roll number 61471 had scored 122 and 126 marks respectively. But they were called, but he was not called. So that is a grievance, and he is general category candidate.
Yes, my lord, I received the instruction.
is the assessment correct that he got 158?
Huh?
Is
No,
it
no, that is his own assessment.
no, is it correct?
No, absolutely not.
What is the
That is
mark
yours.
code?
That is the instruction, my lord. I will also finish.
What is the mark code? What is your name? Masood Ahmed.
Masood Ahmed.
You got 105.5.75.
105 cutoff
Cutoff is 117.0.
Last candidate, 119.
117.
117. So, my lord, in that case, my lord, as per my assessment is 128. As per official answers key, I have calculated, my lord. Now, my lord, in that case, they have to file the OMR sheet, my lord.
So which OMR sheet filing is not necessary. Why should they disclose everything
Yeah, that is
in
the
the
problem,
public
my lord.
domain?
And probably,
Something between you and the commission. Why should they file?
My lord, that
They
is my
can,
OMR.
you can say that they can file an affidavit. We can insist on filing.
I'm saying about that only, my lord.
File an affidavit.
They have to file an affidavit with the OMR sheet, my lord. Then
OMR sheet we cannot, my lord. That is, we are
You can have the OMR sheet
we can
page 44 in the 6th hour. That part, that the
No, my
most
lord,
we can-
AMR sheet, my lord, your lordship kindly see what is his given, what is his case. Is it that, my lord, he's wrongly calculated? His as per the answer key, as per the answer key, he has, my lord, an act, my lord, that is the provisional answer. Thereafter is the final answer. He has to give objection, my lord. Any events is
How can
here.
you file the affidavit?
So, my lord,
affidavit
he is
with
not
the
qualified.
OMR sheet, my lord.
No, OMR sheet we
Because,
Because,
cannot.
my lord, I
No,
should
we
get an
cannot.
Why not mention?
Women, that,
No,
my lord, it will be.
my lord. My lord, I am saying that it is 128. They are
We'll
saying,
record it.
they are saying that it is 105.
Already, my lord, I
Now
dispute
that
the
thing
matter.
can be cleared only by
No,
OMR sheet,
yesterday, my lord, you see that matter, my lord. Yesterday, you already passed the order, my lord.
They passed before order. Notice was not because they get a picture. For the not for the petition. Petitioner is an aspirant, was an aspirant in a recruitment process for taking up post of assistant engineer David under the joint cadre of the PW, which was advertised on 15/3/2020. The petitioner belongs to unreserved category, and the screening test was on the basis of OMR. The projected case of the petitioner is that as per his assessment, he should have secured 128.5 marks, whereas the cutoff for unreserved category, whereas candidate belonging to the unreserved category securing 122 marks have also given the benefit of selection. Para 3 Mohanta, the learned senior counsel for the APS, has however that as per written instruction, comma, the assessment done by the petitioner is incorrect and the total marks obtained by him is 105.75. Whereas the
That's candidate.
cut-off mark for unreserved category male is 117.00. That notice returnable by 3 weeks. Further, the board and the state council has notice on behalf of Representative Anand, whereas M. Sharma,
P.
P. Sharma, Learned Counsel, Mohanta, the senior counsel for accept notice on behalf of
345.
the respondable 4 and 5.
345.
That extra copy be served upon Learned Counsel for the respondable. Right. This on we have it on immediately on the on 8th of November.
Now, my lord, the Viva Voce is underway, my lord. It is going on, my lord. Today also it is there, my lord. It will be completed on 17th, my lord. Now, my lord, in the event I succeed in this writ petition, my lord. That's why, my lord, one post may kindly be kept vacant and I may be allowed to participate in the Viva Voce. Otherwise, my lord, my
The Senate Council pays for an interim order. The effect that one kept vacant and he may be allowed but in the interview which is going on. On a prime facie satisfaction that the mark secured by the petition is much less than the cutoff mark, the interim prayer is
same text, my lord.
My lord, in different ground, my lord, it has been rejected, my lord, because his non-darkening of my lord series. Yesterday, you all
or series. That may have dismissed.
same both in next one also. They are not darkening of the series, man. Which cannot.
This will dismiss.
It is to candidate, na.
Let us see your
Yes, my lord, that is, yes, this is the instruction, my lord. And this is the usual OTP. This is the court copy, it is not yet open because it is still, my lord, completion of the, that is what a court to pay is, my lord. It is not darkening, my lord. It is, when I have,
who was the council yesterday?
you can,
You can.
it is to darkening. It is darkening, my lord.
And what are the case laws?
Case flow, my again, I.
Oh,
Yeah,
we have. I think we have noted in the.
Already, I have, yesterday, I have given all figures, man.
My lord, the other case, if they have the OMR sheet, I can have it, I can pay
No,
it,
no,
my lord.
that is different, man. Because
No,
non,
here, this one.
My lord, if he has the OMR sheets, my lord.
Yes.
Then for the,
This was not even evaluated because it was not darkened.
not related.
if they have the evaluated one, my lord,
In which case?
my lord, just that one.
Earlier case did file affidavit. Let us.
Evaluate fine.
Well,
थोड़े darkening করে বলে না darkening লইয়া লেখা আছে না contrast it will be darkening without darkening that will not be evaluated.
this is cost of that.
Yes.
We have opened.
So that is the instruction that will be put record, man. That is
The same order will pass. We have the instructions part of the record.
to photo to
But we cannot have the original copy. You give a copy.
Yes,
No, this is addressed to you. Will not have.
my lord.
Give a copy.
Yes, we have a photo. So that is there is a clear instruction, my lord. There is instruction also, my lord, is a booklet also. But that is, my lord.
No, yes, we have
That till, my lord, there is in our division based and as well as the honorable office to judge.
Same.
Same. No, put here, man, can you understand? without tracking the full-time.
No, these are very
Not
unfortunate
the
case, Mr. Khan. Some brilliant students may also miss out, but this is have to be mandatory. Because the answers may be all correct, but the computer will not recognize. And Supreme Court has said that for a
Also
particular
our
case,
division
break
better.
is,
Yes, I understand, my lord.
this you have seen this. Mr.
The
Mohanty,
second is also same. Then
which second? One more case,
one more case.
three cases,
Total three.
Three.
14 non-darkening.
Not again.
Let us see the this thing. Still covered, please, then better.
কি লিখিছে নহয় কি ডাৰ্ক কৰিব লাগে
Ah,
that is there
answer sheet, so directly roll number tells to the
then
field.
it cannot be
All the given roll numbers needs to be darkened,
yes my lord.
the
That will not be taken.
series,
So for that my lord they are up to take seat prior to that my lord. Everything they have to my lord given time.
They have to mention the letter and also darken the same. Both thing has to be done. They have mentioned, but they have not darkened. I think computer cannot
That is the-
identify in that way.
exactly. One division में से
these
Still
may
good.
be brilliant students, but we have a separate piece of instructions here. Mr.
here also input it. Separate my lord.
Photocopy.
I'll give photocopy of my instruction my lord for all like.
Right.
So already yesterday that judgment if your lordship my liquid I'll give it again.
No, no, we have it.
So in the appeals court judgment clearly stated the instruction given in by the commission is a mandatory. So that is my lord, the appeals court judgment clearly deal with. And also our high court division mentioned.
My lord. Oblige, my lord.
Lordship, in this matter, the petitioner was appointed as Anganwadi helper, Lordship, on ad hoc basis in the year 2008, Lordship. That is our appointment letter, page 18, Lordship, annexure 1.
Then what happened?
And then since then she is working, your lordship, and later on when the worker was promoted, lordship, she working together as helper and worker, lordship, since 2008, lordship. Her service was utilized and then an advertisement was issued in the year 2022, lordship, for upgradation. The petitioner accordingly applied for upgradation, but her case was not considered. And no written reply was also given. Now, lordship, another advertisement was issued reserving the said post for SC candidate, lordship. So my grievance is that, lordship, as per guideline annexure 9, page 70, lordship, clause 2, lordship.
70.
Yes, lordship. Only those Anganwadi helpers shall be eligible for promotion under this scheme who have been in continuous service for a period of 10 years and above, lordship. So they have utilized my service since 2008, lordship. Now how, lordship, this advertisement can be
This is
issued,
only an
lordship?
eligibility criteria, madam.
Lordship?
This is only an eligibility criteria.
Lordship, earlier that the advertisement was for upgradation. Accordingly, I
No, you
applied.
cannot upgrade. It's an open market. You have to compete. This is the eligibility 10 years.
Lordship.
You have 10 years, you have to compete.
And Lordship, may kindly peruse page 71, the point 3 of the guideline, Lordship.
Yes.
Only
Pass,
those-
these are educational qualification
Yeah.
and that is the
And
eligible 10
no such
years.
statement in the petition that the petitioner has passed the class 9 examination.
Lordship, that
Okay.
instruction I have not taken. Otherwise, lordship, her long continuous service, lordship.
That will not come into effect. It's not question of upgradation. You can be made from a helper to worker in an open competition amongst all the helpers who have completed 10 years of continuity.
In the sector, lordship, except me, there is no other helper.
Very good.
lordship. And they have
You will be
utilized
the
my
only
service,
candidate.
lordship, since 2008, lordship, as a helper and subsequently as a worker also, lordship.
That you have volunteered to do.
Lordship.
That will not give you any right.
And since then, they are paying me salary also, lordship. That
That is
honorarium
very
salary,
good.
lordship.
We have dismissed the petition just, I think, 2 days back on a similar ground.
Then Lordship, I will go through that judgment. Your Lordship may take it up on some other
Where
day, Lordship.
you go through this judge, your
So, Lordship,
which you are
before-
passing.
Before that, Lordship, some time may be given, Lordship. If
There's
your
no
Lordship has
question,
already
there-
passed an order, Lordship,
There is no question of granting any time. There is no right, enforceable right. And you know about this notification of 2030. It's this notification which is the governing the recruitment.
no, Lordship,
Heard.
this notification says, Lordship,
Heard.
Lordship may take up on tomorrow, Lordship. Tomorrow, Lordship,
The
as a
invincible
motion,
which is going to happen, no point in delaying that.
Lordship, tomorrow, Lordship, in the meantime, I will go through that judgment, Lordship.
The judgment is an order. We are passing the same order. The heard. MS heard so that council and also heard the SR board was that state council. Considering subject matter involved and the prayers made, the state petition is taken up at the petitioner claims to be appointed as the Anganwadi helper in the year 2008 in the center number 85, Onachera Grand, Lala in the district of Hailakand. So the initial appointment was on ad hoc basis for 2 months, the petitioner was allowed to continue and is doing so. It is the case of the petition that the Anganwadi worker in the state center was promoted to the post of supervisor, and in the state vacancy, the service of the petitioner was used as
If your
Anganwadi.
Lordship, if one chance to take instruction whether I can withdraw this petition, Lordship. After some time, your Lordship,
Even if you withdraw it with
before,
we'll say something that in the
Lord.
we'll dismiss your claim, but we'll say something. Anganwadi worker. Sarah. On 23/2020, an advertisement was issued for filling up the post of Anganwadi worker in which the petitioner had applied, but there was no response. The petitioner is now aggrieved by an advertisement dated 21/9/2023 for filling up the state post. Full stop. Sarah. Ms. Chaudhary, the learned counsel for the petitioner, has submitted that the petitioner is rendering continuous service for almost 1.5 decades, and the same, and by ignoring the same, the present advertisement has been issued. Full stop. Reliance has also been placed upon a notification dated 4/3/2013, laying down the guidelines for appointment, and emphasis has been laid on clause 2, which requires a 10 years continuous service for the Anganwadi helpers to be eligible for consideration to the post of Anganwadi worker. Sarah. Ms. Chaudhary, the learned counsel, according to submission, that the impute advertisement be interfered with, and a direction be for consideration of this for per contract, the Borua, the Learned State Council has submitted that petition has been structured on a misconceived notion. By referring to notification date 4/3/2013, which based on the guidelines from the Learned State Council has submitted that the guidelines only relate to the eligibility criteria for being considered for promotion, and 10 years of continuous service is only an eligibility criteria and not an indefeasible right to claim appointment, to claim promotion. He has also referred to clause 3, as per which the educational quality has also been laid down. At this stage, the Learned Council for the petitioner submits that the petitioner is the only Anganwadi helper in the
Monachara 85 Anganwadi.
in the center.
Yes, Lordship.
But is it
Still, she is doing the work of
in the
Anganwadi
center?
worker.
After hearing the parties from this court is of opinion that the notification dated that 4/3/2013, which based on the guidelines only pertains to eligibility criteria and cannot be construed to vest any right to claim promotion or to an Anganwadi helper aspiring from an Anganwadi work. So the fact as project may lead this court to a conclusion that the petitioner is eligible, such eligibility is only with regard to the participation in the recruitment in the promotional exercise, which has been done by giving opportunity to all similarly situated eligible candidates. This court finds court in contention made on behalf of the state that no indefeasible right is vested on an incumbent holding post of Anganwadi helper to Anganwadi worker by the notification dated 4/3/2013. The petition is according to health responsive and it is however observed that in the event the petition applies for the post of Anganwadi worker,
She is a general category. She is a general category candidate and it is reserved for SC.
In the new notification, we have provisions for that. For a particular
you don't belong to that category then
because
you have to challenge. You have to challenge on different grounds. The earlier candidate was which category? Who had retired? Who was promoted? You say in 2000 something somebody was promoted from
Yes,
worker to supervisor.
Yes,
we have notification of
She is
21/7/2016
Manjushree Sarkar.
where it is provided
She
that
handed over charge to the
a particular community is having more than a population of more than 40%, then it itself is
Sorry, that part you can come into your
Okay.
One is that. Who is your counterpart?
Your Lordship, I have also newly engaged in this matter.
12 matter.
Just 2 weeks before and 1 week before I received the brief from the bank. Earlier it was a 2012 matter.
What is
Your Lordship, the matter is in regard to something that is the
sitting or some loan?
no. It is not regarding the loan. It is a service matter.
100%.
Yes, sir.
Penalty is
Yes, compulsory retirement with superannuation benefit was given.
don't need non-applicable. Whereas
1, 2, 3, and 4.
challenge is that a penalty on with
Superannuation.
retirement benefit. Treated as a further chance to represent the matter that on one of further right of the
Hello.
So Malakar, what is this?
Make this
Yes, ma'am.
report for SCF matter.
Your senior is Mr. Bodloy.
Yep.
He's out of state. What is the matter?
It is matter, promotional matter of the employee. It is
Of the Corporation Department. Corporation Department.
cooperative department.
When did Mr. Bodloy come? On?
7.
17th. 17th will be difficult. Last week we'll have. Is he coming back day after tomorrow?
Yep.
Seventeenth, the last week motion. Friday is will he be back this Friday?
Yes.
And will he come to the court on Friday?
Yes.
And then 13th will fix it. Okay.
13th Friday.
So these are old matters. We not like
Yes, my lord.
those three. Malakar, let us count. Present comma. A prayer for accommodation has been made by Miss. What is your name?
A.
Give your name. On behalf of Sri T. Bodloy, Standing Council, Corporation Department. Considering that in the year 2012, by a short accommodation raised the direct on 30. affidavit filed, Mr. Parasar.
My lord,
Readings are completed. There was there filed a reply to a rejoinder. Anyways,
Try to rejoinder.
reply to rejoinder.
Under what provision?
bring some facts.
You take view of the no concept of reply.
Anyways,
Only in the petition that you are getting a chance of even a rejoinder. Otherwise, plain written statement, reading the rule. Yes, when do you take it up for disposal? What is the matter about?
otherwise, your lordship, the matter is covered. The petitioner on a early
What is the subject matter? Tell us.
subject matter is basically he wants NOC to join the ICR, the private respond number 8. So he is presently working in Borderos organization. In the ICR, they actually floated one advertisement seeking application from interested candidates who are working at the central government department to
ICR is a part of the central government.
so they
You want your present employer to give an NOC.
NOC.
They are
So
not
to
giving
say,
it.
they are
So
not
that is
giving
the
it.
cause of it.
I want to just give a technical resignation in terms of the there are many OMs.
Do you have any difficulty in giving?
My lord,
So that is what they are
fact is
telling.
that malad they applied from the malad his unit malad it was NSP was given by the unit at that time. But any such appointment has to be routed to the malad directorate malad. That was not done.
Directorate who's for the director?
Malad, I am appearing malad. At that time it was not done. Because of that malad that was cancelled by that unit subsequently. And it is our malad he has directly approached the authority without routing the malad to the proportional malad.
Now you are in the no you can now you take
Now malad fact is that malad
otherwise is there any disqualification or something else that he cannot give an NOC? It's only because of the procedure.
procedural that and
Now you can adopt the procedure. Don't you have formality?
In fact, I am willing to let go of my past services also. Very recently, Supreme Court judgment said that if he is willing to let go,
Mr. Parasar, you should not have any issue, serious issue regarding his leaving the organization. It's only because of some procedural lack of formality. Then I think it's not a reason to be even contested.
and
We'll
regarding
record your submission. We'll ask him his application to be routed to the directorate.
and the issue is very simple as such. The petitioner, he earlier approached the department for NOC for applying in a different organization. That was Coal Provident Organization. And same fact, same everything same.
What happened then?
There they rejected it and I approached the Honorable Court. Honorable Court said that there is no bar as such to accept the technical resignation. If somebody doesn't want to remain in an organization,
You
how
cannot
can-
force him.
you cannot force it. This will lead to a new form of manual labor, basically. So
Bonded kind of a thing.
and bonded kind of labor. And the Honorable Court directed them to give the NOC, and they had given the NOC. But unfortunately, the last date was over by the time they gave the NOC. So that case became infructuous. So again,
Now is the ICR they ready to take?
Yes.
malad that is there malad one post also came vacant as per the interim order is there. Malad but fact is that malad regarding malad to leave this malad technically it is there. Technically malad we are opposing malad.
in fact, as per guidelines, I'm supposed to give a resignation. I'm resigning it and I'm willing to join and let go of the past service.
State the fact in brief, very brief.
Yes,
We'll dispose it.
One fact is that malad
First, let him give the fact, then come.
Your Lordship, the ICR respond number 7 issued a vacancy circular at page number
Just a minute.
38.
Yes, what is that?
Page number 38, Annexure 1. They issued a vacancy circular wherein in the application
Date,
dated July 6, 2018.
6, 7, 18.
18.
Vacancy circular.
Vacancy circular for transfer / absorption against for vacant post of LDC. The petitioner, he was working as a LDC in the Borderos organization. He is presently working as a LDC. Now petitioner, he participated and his application was forwarded at page number 42 and the relevant portion is at page number 43. wherein the commander of the officiating unit forwarded his-
When is the date of the forwarding?
it's 10th October 2018.
10?
October 2018.
Okay.
And therein, he was ultimately that after forwarding, his application was again approved for permanent absorption or transfer basis by the ICAR on 13th of June 2022, which is at page number 45.
Okay.
45, Your Lordship. Thereafter, Your Lordship may kindly note the date here, 13/6/2022. And it was forwarded in 10th of October 2018. After 4 years, due to COVID and all, they ultimately selected him in 2022. Then he came to know from one impugn order dated 16/10 to dated 14/7/2022, annexure 13, page 56.
What happened here?
Therein, the impugn order was passed, stating that his application could not be forwarded, has not been sent by WB, that is the unit, through proper channel to ICAR veterinary. Further, the unit has stated that the forwarding letter was cancelled subsequent. This particular cancellation,
One second. What was the initial application was not forwarded by?
his unit,
No,
it was cancelled.
that was the cancel earlier forwarding. Now, what was the
Initial reason was that the unit had cancelled his application. It was not forwarded. Because earlier, as I stated, on 10th of October, it was forwarded with initial stamp and signature of the commanding.
Understood. Why is it been cancelled?
Then again,
Why is it been cancelled?
it has been stated at page number 57.
Yes.
Page number 57, I'd just like to read out. His application and forwarding letter dated 10th October 2018 mentioned in your letter at reference number B was signed by signing authority erroneously. And same was cancelled on same day, that is 10th October 2018, being not covered under rules of this department. Moreover, the application of the individual has not been forwarded by this office at the same time as the same has been cancelled and the same confirmed by a letter. This he only came to know on 14th of July 2022. So here I rely upon Bachitra Singh, Your Lordship.
The information regarding cancellation of the initial forwarding was given to you only on 47/20.
14/7/20.
And the reasons is that it was signed erroneous.
Erroneously.
Now, what was the erroneously? Weren't you eligible?
No, I'm eligible.
Then what?
I'm LD.
Then why is it erroneous?
Just they stated at page number 57, it was erroneously and not as per rules of this department.
Rules not for.
Rules not followed.
What rules not specified?
Basically, at page number 58,
So, for what rules not specified?
what rules not specified? Also, they handed me over one letter from the ICAR dated 16/10/2018, wherein the ICAR stated that only one blank piece of paper was found within the envelope, that is a forwarding letter sent by the. Even after that also, ICAR selected me. I don't know how, but ultimately I was selected in the year 2022. So that is there. Ultimately,
Okay. That blank paper may not have much.
yeah, it doesn't have that much relevance because after offer of appointment has
Okay,
been.
this is the basic. These are the basic facts.
Yes, Your Lordship, and the petitioner on an earlier round of litigation, if I may stress on that, on this honorable court, at page number 110 of this in WPC, at page number 110, observe that this
Date.
the judgment dated is 21 to 2017, WPC numbers 31 of 2017. It starts at page number 104.
Okay, what was the order? What was the, this was a similar case of your
Similar.
deputation, if you're going to somebody else,
Yes, yes.
which is the organization involved?
It was a Coal Provident Fund organization. The petitioner was a petitioner in this particular.
Understood. You wanted to go where?
Coal para number 25
Of 112.
of 110. I'll just read out your lordship. Just quickly. The matter would, however, be entirely different if the petitioners choose to resign from the jobs and join the new employment. In such cases, in the absence of any departmental proceeding pending against the petitioners or any penalty imposed upon them, the authorities would be obliged to issue them the NOC unless there is any contrary provision to service rules. If the dissatisfied employees want to leave the organization due to lack of career advancement opportunities, it would be a matter entirely for the department to address, but the BRO cannot compel any unwilling employee to continue in service against his wishes. In view of the pleaded stand of the respondents that the writ petitioners are at liberty to leave the organization by submitting the resignation, that the respondents would be obliged to issue the vigilance certificate and the NOC to writ petitioners if they resign from the present job. In any event, in view of clause 8 of the circular dated so and so, the petitioners would not be entitled to any credit for the past service except for pensionary benefit applicable in cases of those employed not covered under NPA. Accordingly, next page itself, in terms of the judgment,
You wanted to go to Coal Mines Provision Fund organization.
Coal Mines Provident Fund organized. In terms of the judgment, next page itself, page 112 and 113, NOC was issued.
On one.
Next page itself, that 113, your lordship, is the NOC. 112 is the covering letter to the Coal Mines Provident Fund organization. But the last date was over by the time it was, so he could not join. So that is nothing.
My lord,
We have already submitted that for the technical.
Yes.
You can just elaborate what the technical is and how can you overcome. You can submit on that, you can pass necessary orders.
Right.
How it can be overcome, because on principle it doesn't appear that you have an objection of his leaving the organization. It is only due to some non-fulfillment of
my
some
lord,
formalities.
regarding my lord, his offer of appointment, that letter from the ICAR, my lord, here, my lord, once we peruse in the affidavit page 188. Page 188, annexure F. my lord.
One eight.
188, annexure F of the affidavit. my application. Relevant portion, my lord, here, my lord, page selection, my lord, regarding the conditions, my lord, page 198, 189, my lord, next page.
What is this?
Offer of appointment.
Offer of appointment, my lord, by the ICAR, my lord.
That
My
one
lord,
nine.
page 189,
What's your name?
Hashim Ansari. Mohammed Hashim.
page 189, my lord, clause 6, my lord, his transfer will be subject to the all India transfer liability as per the standing circumstances. Next 7, all other conditions service will be governed by the relevant rules. In case Hashim Ansari law, for instance, accepts the post on the terms and conditions stipulated above, he may be relieved with the instruction to report for duty ICAR Patna within 21 days from the issue of this letter. The character verification report, medical fitness certificate, requisite clarification statement, furnished, etc. law revision start at the time of his initial appointment at your organization may please be sent. So, my lord, these are the conditions that he is having with the previous, my lord. This has to be followed with his up-to-date service book. That has to be, my lord, carried out. So, my lord, regarding my lord may come to my lord.
Next paragraph also your lordship may read. It is further requested necessary formalities as per UI guidelines in a matter of permanent transfer of a central government employee to an autonomous organization may kindly be completed with the approval of competent authority before relieving.
So, fact is that their approval of the higher authority was not there. Only because of that. That letter subsequently cancelled.
This letter.
No, this not this letter. Earlier letter whereby the unit 10/7/2022 it was cancelled by the authority. Already he has
10/7.
10/10.
10/10 it was cancelled.
What is 10?
That is a forwarding letter.
Forwarding letter.
Page?
Uh,
10/10/18.
in 190.
43, 44.
10/10/18 you have said.
Yes, 10/10/18.
10/10.
Page 44.
In a affidavit of 190.
Annexed
Not 10/10/2022, 10/10/18.
18.
That is the letter what informed in.
No, but this letter which you are trying to rely on page 118, this is essentially addressed to you. It's not the petitioner. Petitioner is only given a copy.
Yes, my lord.
Now these were the things which you as the employer had to do.
Yes.
And petitioner was only given information by marking a copy to him.
Yes.
Now you say that the employer had not completed this thing.
No, my fact is that as per the necessary formalities as per the approval of the authority, approval regarding these things, because the higher authority has not been approved, the initial letter of that was cancelled. Then it was 2018 already cancelled by the department. Yes, one fact is that he was informed later on. That is on the record, my lord. Now, guidelines are, we have annexed in page 1206 in our affidavit.
No, but then question would arise that can petitioner be faulted on? If he had not taken approval of the higher authority, the immediate authority had given some certificate.
Yes.
That and you later on said it was erroneously done because he did not perhaps have the power and authority because it was not rooted by the higher authority.
Right.
Now for that can the petitioner be set fault? That's one. And if you are making a submission that it's only for that reason, otherwise higher authority does not have any difficulty if it comes through the normal process.
So proportional.
It is up to you. What can he do now? And this the offer of the idea is as late as 36/2020,
Yes.
which Mr. Bora is saying that it's still open and there is one post vacant.
That is the interim order. Is
Not much problem.
that procedural regarding this we have annexed in page 206 annexure L of the affidavit 206 annexure L last but 3 page of the affidavit 206.
Yes.
207 clause 5. Procedure to be followed in case of those who apply for post in the same public other central government department.
These are part of what? Chapter 44 is part of what?
These are BOPT guidelines.
BOPT guidelines.
I have annexed the latest one also. BOPT guidelines.
And page number 207.
Where is first page? Regarding the guideline.
Guidelines मतलब page 207 मतलब relevant portion, clause 5. Clause 5 मतलब the following procedures should be followed मतलब Roman 1. The application may be forwarded in accordance with the general principles contained in the MHA OM that irrespective to whether the post applied for in this other department office is permanent or temporary. In case of permanent government servants, their lien may be retained in the present department office for a period of 2 years. These are the मतलब and one thing is that मतलब regarding border routes मतलब border routes organization मतलब VFs मतलब services in the remote areas and hill areas मतलब people may come from different parts of the country and join in the border routes for the sake of doing job now मतलब he wants to go Patna for better place of yes मतलब there is no if you will go now मतलब such several petitions will come several petitioner may apply if they don't want to serve in border route in a hill area, they want to get a better place. If huge people will come, then it will be difficult for the organization also. Organization has to run.
You can't reject application.
No, yes.
You can very well reject. Short of the manpower, you cannot let go. That you have not said here. It's up to you. If tomorrow all personnel say that no, we to leave the organization on some other, will you allow them to leave? Obviously not.
Because several construction.
And in today's context, when there is lack of employment, there will be thousands to join here.
Yes.
There is no question of shortage of manpower. Considering the issue involved and the fact that things are this is taken up for this was at the issue for cancellation of an earlier approval for the petition to join is the one number 5 or 4 organized 5
number 6
organized
no 7
No, 7.
7 organized. Sarah. The petitioner is presently working as the lower division and clerk in the border road organization. Union packet GREF. GREF.
Number 6.
On 6/7/2018, a vacancy circular was issued by the SP number 7 for transfer of the absorption asset of LDC, pursuant to which the petitioner had applied. It is the case of the petitioner that on 10/10/2018, his application was duly forwarded by his employer after after passing of subsequent on 13/6/2022, the responsible 7 had approved the state application of the petition. However, by June order 7/2, the petitioner was informed that the earlier letter of approval by lawyer was cancelled on the next day itself, and the reason for such cancellation was that the forwarding was issued erroneous as rules were not followed. This is the correctness and health of ordered the that I have heard three forums where it comes where the respondent contest
1 to 6.
by Madam, your phone
7.
is here. This one for 7 by art forum. You have anything to say? Are you ready to take him with? For us, I have the same. That the matter of routing the application from procedure at them, and so far as his route is concerned, he had duty made the application pursuant circular date 6/7 submit that once the application must be forwarded and the petitioner had that it was done by following all necessary procedures. Further submit that at no earlier point of the was ever formed about a time of earlier by parent organization, and shortly after that I responsible step had approved by that the income from it 7 has passed. Later that was by the company voted that the had come for such method for the better. Before us has also referred to an earlier case by it was by every third test of that is of a similar situation for that very petition was attempt to move the court might pass organized person or person to an assessment was held up due to lack of no consent. However, this by order to of the and and for which was actually done subsequent. However, since the last date was over, the petitioner could not avail of the opportunity to join the state organization named the Coal Mine Provident Fund Organization. Sarah Deborah submits that since the issue involved in the present list is similar to the list which has already been resolved by the court in the earlier round of litigation, necessary directions may be issued to facilitate the petition to join the response number 7 organization. He further submits that in terms of an interim direction of past in present case, a vacancy exists. No, a vacancy, a post is kept vacant, wherein the petitioner can be accompanied. So, Sri Parashar, the learned thesis, appearing for contesting response number 1, however, submit that in the offer of appointment made by the ICR by communication date 13/6/2020, which has been annexed to application of petition filed on 16/3/2020, the conditions have been laid down, and unless an instance is the conditions were not fulfilled, and therefore, on the very next date of forwarding of the application to petition on 10/10/2018, the same was withdrawn. He submits that since the application of the petition was not approved by the prescribed higher authority, the letter dated 10/10/2018 would not have been issued, and there was a jurisdiction error, and therefore, in the impugned order dated 14/7/2020, the same has stated that the forwarding letter dated 10/10/2018 was erroneously signed. The learned thesis has also drawn the attention of the court guidelines of the
COPT guidelines.
COPT, more particular rules concerning within forwarding of application or other employment. But by referring to clause 5 of state guidelines, comma, the legislature submit that the procedures have been laid down in state, and unless those are meticulously followed, comma, an employee for which the parent organization will not be allowed to leave and join some other. Sarah? Ms. R.B. Bora, the council representing respondent themselves while endorsing the submission of Maharashtra has, however, that if there is that the offer letter dated 36 was given on the assumption that the approval was duly given. The further submit that in terms of interim direction of comma, a post has been kept vacant, and if due approval is given by the parent department, there will be no difficulty to absorb. The travel content made by the Learned Council for the party have duty considered, and the material is have carefully examined. Sarah? To determine the issue which is arising from this court is benefited by the earlier order passed by on 22/2/2017 in the application 31/2007 instituted by the same. This court was dealing with an ideal situation wherein the petitioner wants absorption in another organization, named the Coal Mine Provident Fund Organization, and the matter was held up for non-grant of NOC. Court in paragraph 25 of the state judge has observed as follows. Page 26 also. That the Bora Senate Council for has however informed that though subsequent the NOC was issued, the matter was rendered, the same was rendered OTOs as the last date was already, last date to join, last date for such absorption was already over. Full stop. Sarah? In the instant case, this court has also noticed that the application of the petitioner was forwarded on 10/10/2008, and the petitioner would not have any role in the procedure adopted while issuing such forwarding letter. And this court finds forth in the argument that the petitioner had reasons to believe that the due process of law was fulfilled. Full stop. This court has also noticed that in the offer letter by the ICAR dated 13/6/2020, where certain conditions have been laid down, the state letter was addressed to the employer, present employer of the petitioner, and only copy thereof was marked to him. Full stop. The conditions stated for such absorption were required to be fulfilled. Which were required to be fulfilled could be assumed to have been done when the forwarding letter dated 10/10/2018 was issued. Sri Bora, the learned counsel for the petitioner, has also informed that at no earlier point of time, the petitioner was informed that the initial letter of approval dated 10/10/2018 was cancelled on the very next day. This court has also noticed that if such forwarding was cancelled on the very next date, how could an approval be issued by the ICAR as on 13/6/2022? Be that as it may, without even going that aspect of the matter, this court has come to the conclusion that fulfillment of the condition would require certain acts to be done by the present employer, which would also require the clearance and approval from the appropriate authority, as mentioned in the offer letter dated 13/6/2020. This court, in the earlier occasion, while adjudicating WP 31/2017, has already laid down the principles. Following the same this court directs that the RESPA numbers 1 to 6 would take up the matter earnestly and complete all necessary formalities of fulfilling the conditions for facilitating the petitioner's absorption in the Respondent 7 ICAR. Also, this court has already noted that one post of LDC has been kept vacant in the ICAR pursuant to the interim direction of this court, and Ms. Bora, the learned counsel for the ICAR, has also submitted that in case the application of the petitioner is properly rooted, the respondent number 7 would not have any difficulty in principle to observe the petition. In view of the above, the intent petition stands allowed. The aforesaid exercise be completed expeditiously and within an outer limit of 4 weeks, 6 weeks from the
Your Lordship, the impugn order dated 14/7 so may be quite rejection. Impugn rejection letter dated 14/7.
It is necessary to
They turned down the request.
the consequent transport the impugned order that 47 is according to status. Highly obliged. Interim order stands merged with time.
Your Lordship will recall there is a direction to file the affidavit. That affidavits have been filed, my lord, on time, and the case is ready for admission hearing. My lord.
What is the
Senior is unwell, my lord. That Hakuti.
IIT matter?
Yes, my lord.
What is
May-
this matter?
Okay, so I think
My lord, we challenge the DPC recommendation and subsequent appointment of the private respondent in this case
As
as external for the post of external registrar.
not well.
Yes, my lord. Yes, my lord.
Can I have some
Thursday, my lord. Thursday, because next week will be, my lord, the motion.
next Thursday?
He's viral fever and foot malady.
Well, let us see.
On Friday,
Then we'll have to.
Friday.
Let it be kept on Thursday, my lord. Let us see. Let us keep our fingers. It's for the private.
We'll try on Thursday if there's a
Yes,
difficulty.
yes, yes. Yes.
Then we'll
My lord.
postpone. A prayer for the okay. Why on Thursday? We'll have it after the
My lord, there is urgency, my lord. This is absolutely illegal. My lord, there is also a direction, my lord, for admission disposal, man.
we'll have it for admission. It's not fair. Why? Yeah.
My lord, per se, my lord, this is entire action is illegal, my lord.
That's something different. We are on the artist part. We'll have to leave.
Or on Tuesday, my lord.
No. It's not possible. We'll have to leave. We'll fix the date.
But issue is very short, my lord.
Not issue. That's why we'll.
My lord, on Thursday, my lord.
It's not fair.
Look, that is understood, my lord. He has. I have
If we
consented.
pass an order, he'll be more unwell because of the pressure from the court.
My lord, they have been taking time, my lord, on several
23
occasions.
matter. How much time will it take?
They have been.
Also, DT Goswami that attorney counsel for the petitioners over one petition,
Mine. One.
petition, whereas DT Mansalan for the response.
P9.
There are two matters.
Yes, my
My
lord.
lord, initially we challenged the DPC recommendation and during the pendency of that
petition.
petition.
For
appointment.
the private response. One respondent, man.
One.
Since Goswami has expressed certain urgency from these cases for hearing on. We'll have it on 5th or 7th of November. Reopening. 6th we are reopening.
7 is Tuesday. What's up?
May it please your lordship. But this matter relates to appointment of Muzadar. What has happened, my lord? The last Muzadar. Meetings are over, Sada? Yes. Disposal is possible? Disposal hearing. Yes, tell us fact. The last Muzadar of the Kanpur Muza expired, my lord. He died. But Muza, my lord, Kanpur Muza, my lord. My lord, pursuant to his death, my lord. My lord, Kanpur Muza. KMPUR, Kanpur Muza. Nagaon district. My lord, page 20 is the appointment order, my lord, of the writ petition, my lord. His father was the RTM Muzad. Lordship? Father was the RTM Muzad. His father was the RTM. Satyendra Goswami. Satyendra Goswami. Earlier Muzad. The deceased. No, husband. Not father. Husband is the petitioner. My lord, the wife petitioner is the wife of the deceased Muzadar. Yes. But the deceased Muzadar was appointed in place of his father, my lord. Okay. What is the name of the father? Father was Satyendra Goswami. Father of the? My lord, Krishna Chandra Goswami. My lord. Krishna Chandra Goswami. Krishna is your father-in-law? Father-in-law. It may have page 20, the appointment order. Wife of deceased Muzad. Of the deceased Muzad. Name? Satyendra. Satyendra Goswami. Okay. What happened there? My lord, Satyendra Goswami was appointed in 1989. Husband was appointed. Husband was appointed. When his father, my lord, due to his old age ailment, was the then Muzadar, was unable to perform his duty. In place of his father. In place of his father. Yeah. Now, my lord, after Satyendra Goswami died, my lord. When did he pass away? 89. No, my lord, he passed away recently, my lord. Satyendra Goswami, my lord. 13/8/21. 21, my lord. Satyendra passed away. Passed away, my lord. After his death, my lord, the petitioner, being the wife, applied for being appointed as the Muzadar, my lord. Now, my lord, the authorities, respondent authorities, they have approved the appointment, which is the impugn order, my lord, Annexure F, page 27 of the writ petition. That's number 4 has been appointed. Yeah. Is 15 June. Lordship, 15 June 2022. With reference to the above, the appointment of Sri Hemanta Goswami, son of late Hiranya Goswami, as Muzadar of Kanpur Muza, is approved, undersigned as per your recommendation. Now, my lord, is R1, R4, R4, my lord. Now, as per the executive instructions, my lord, framed under the Assam Land and Revenue Regulation, my lord, instruction 116, my lord. Yes, I am just reading it out, my lord. The vacation order. Yes. My lord, principles in making appointment. This you are reading what? My lord, regulation 116 of the executive instruction. Executive instructions framed under the Assam Land and Revenue Regulation. Chapter 8, my lord. 116 I am relying upon, my lord. Otherwise, it starts from 115, my lord. The chapter relating to appointment of Mojadars. Principle in making appointment. Principle in making appointment. My lord. Yes. In making appointments, the following principles shall be observed as far as possible. 1. Mojas inhabited by such indigenous races as Kacharis and Mikis shall be committed to a Mojadar who himself belongs to the indigenous population. 2. Subject to such changes as may be required in order to give effect gradually to the foregoing principle, a Mojadar successor, my lord, it is always a successor, shall ordinarily be selected from amongst the members of his family, including relations on the female side, if no qualified heir, lordship will mark the emphasis on the word heir, my lord, heir is available on the male side. If an heir, again the heir word comes, otherwise suitable is a minor, the post may be kept open for him for a period not exceeding 3 years, an agent being appointed provided that the deputy commissioner is satisfied that the minor is doing his best to qualify himself for the appointment, but the family of a Mojadar who is dismissed for misconduct lodges the hereditary claim. Again, hereditary word, my heir, hereditary, I am emphasizing on this word. Then, lordship. 5 is important because government has taken this step. The qualifications for appointment to the post of Mojadar will include a fair vernacular education. This is the petitioner possesses, such as is required for keeping of Mojadari account. Her husband was Mojadar, she knows it. It is desirable that the education should have extended to the middle vernacular standard. That is also she possesses. Further, other things being equal, my lord. This line that is I am harping upon. Further, other things being equal, preference shall be given to candidates who have higher educational qualifications, such as those connected by matriculation or higher pass. Now, petitioner is matriculate, my lord. Insofar as the educational qualification is concerned, my lord, Annexure Z, page 28. Yes. C is a metric. And the respondent number 4, my lord, is higher secondary part. Yes. As part of government affidavit, that is the only reason why they have given to the respondent number. Now, my lord, my respectful submission that this other things being equal, now petitioner and the respondent number 4 cannot be treated to be an equal pedestal. These regulations were promulgated in the year 1886. Thereafter, the concept of heirship has gone a sea change, and the legislature has brought into the Hindu Succession Act, my lord, 1956. The Hindu Succession Act
which governs all the successions of the Hindu, my lord. Under section 3F, my lord, defines an heir. 3F defines an heir. Heir means any person, male or female, who is entitled to succeed to the property of an intestate under this act. Now, my lord, insofar as the overriding effect is concerned, what was prevailing as a law, my lord, previously has been modified and, my lord, brought into a common platform by section 4, my lord, of this act. Overriding effect of the act. Section 4 of the Hindu Succession Act. Save as otherwise expressly provided in this act.
Yes.
Any text, rule, or interpretation of Hindu law, or any custom or uses as part of that law in force immediately before the commencement of this act shall cease to have effect with respect to any matter for which provision is made in this act. B. Any other law in force immediately before commencement of this act shall cease to apply to Hindus so far as it is inconsistent with any of the provisions contained in this act. Now, my lord, this heirship, my lord, now, after passing of the Hindu Succession Act, if a devolution of the office of Mojadar in my respectful submission is to be made, it has to be made since the word heir finds place in the particular provision. So that principle will definitely invite the attention of the Hindu Succession Act. And the moment the Hindu Succession Act comes into picture, my lord, section 8 is of utmost importance, my lord. General rules of succession in case of males. The deceased was a male. Eight, 9, and 10, my lord. These are very important things. I'm starting from 8, my lord. General rules of succession in case of males. The property of a male Hindu dying intestate shall devolve according to the provision of this. The general rules of succession in case of males, the property of a male the Hindu dying intestate shall devolve according to the provisions of this chapter. A. Firstly, upon the heirs being the relatives specified in the class 1 of the city. So the wife being a class 1 legal heir and the respondent number 4 being the brother's son. Wife. Who is a class 1 legal heir.
And R4?
R4 is brother's son.
Son of brother.
Son of brother.
Of deceased.
Of the deceased. So he falls within the class 2 legal heir.
Nephew.
Nephew.
Class 2.
Class 2, Lord. My lord, B now. Secondly, if there is no heir of class 1, then the heirs being the relative specified in the class 2 of the city. So class 2 will come into the picture when there is no one in the class 1. And the rule equally puts emphasis on female legal heirs, my lord. This is my case actually, my lord. And on the basis of this, my lord, in again section 9, my lord, section 9 also says order of succession among heirs in schedule.
As per this.
As per this.
Class 1 and class.
Class 1 when class. This was my prima facie case. And upon this case being moved, my lord, an interim order was passed. And thereafter, my lord, the stay vacation application was also passed, filed by the private respondent in IA number, my lord, civil 2117 of 2022.
Yes.
That, my lord, IA was not entertained, stay has not been vacated.
Can we have a look at the
Lordship, it is 5/8/2022 order. May I just read, my lord? Heard Mr. Das Planet Council for the read petitioner DP Ghosh is instant. Now, my lord, that the fact that the Mozadar shall be appointed amongst the heirs is no more authentic.
what is the interim order?
My lord,
What is the interim order?
interim order is the stay of that, my lord, that recommendation, my lord, of the commission.
Now who's run?
My lord, now nobody is running, government is running. My lord, previously in a writ proceedings, my lord,
Regarding which?
my lord, who will succeed to the post of my lord Mozadar, my lord, that it is a hereditary right that has found place in a earlier judgment of this honorable court, my lord. And
But the regulation
regulation makes it clear. So it's a hereditary right, my lord. Now, my lord, the stand taken by the government, the respondent number 1 has filed the respondent number 1, who is the commissioner who has approved the order. The commissioner has filed in a joint secretary, through the joint secretary has filed an affidavit. And my lord, another affidavit has been filed by the deputy commissioner.
That's for number
1.
no deputy commissioner is what?
3, my lord. The ADC has filed. My lord, now first I will take up the affidavit in opposition of the respondent number 1. My lord.
Yes.
My lord, their main stand is from paragraph 4 onwards, my lord.
R1.
R1, my lord, paragraph 37, page 37, running pagination, page 37, my
Yes.
lord. Paragraph 4. That this honorable court in its order dated 5/8/2022 passed in the instant case directed to file affidavit making a stand so as to what is the meaning and purport of expression members of his family, that is the members of the family of the immediately preceding deceased Mozadar. 5. The deponent begs to state that the expression members of the family has not been defined in the Assam Land and Revenue Regulation 1886, although it is provided in Executive Instruction 116(2) that ordinarily a Mozadar's successor shall be selected from amongst the members of his family, including relations on the female side. Female side again receive emphasis, my lord. If no qualified heir is available in the male side, heir is not there, my lord. The deponent, and now just for your lordship's information, my lord, the deceased Mozadar had a son and a daughter. The daughter is married to some other family, so she is not claiming here. And the son is already appointed in the government department, so he is also not claiming.
The deponent inquired from the connected authorities to find out if any amendment or modification has been made to explain the expression members of his family. So they are going by the reading of the 1888 regulation, 1886 regulation. The deponent would continue to make an endeavor to obtain further information from all possible sources in this regard and crave leave from the Honorable Court to file additional affidavit. But the deponent also craves leave from this Honorable Court to file a detailed affidavit of opposition as and when need arises or call upon to do so. The purport of expression of members of his family is to be gathered from Assam Land and Revenue Regulation 1886. From the scheme of the Regulation 1886 and the executive instructions, the Mozadar's duties are confined to collection of revenue and other government dues. So this can be done by the wife. The details of duties to be performed by the Mozadar have been outlined in the Assam Land and Revenue Regulation. The executive instruction, again, they have referred to the relevant provisions. That it is relevant to state that two persons had applied to the post of Mozadar in Kampur Moza, Nagaon. One, the applicant, namely Hemonto Goswami, respondent number 4, the son of Hiranya Goswami, grandson of late Krishna Chandra Goswami, second Mozadar, is the nephew of the deceased Satyendra Goswami. The other applicant, Timothy D.P. Goswami, is wife of Satyendra Goswami. Family ordinarily connotes a group of people related by blood or by marriage. In that sense, Hemonto Goswami is related by blood, being nephew of Satyendra Goswami, whereas D.P. Goswami is related to Satyendra Goswami by marriage, being wife of Satyendra Goswami. For this reason, both the petitioner and the respondent have claim over the post of Mozadar. Yes. Now, paragraph 10, the petitioner in page 40, my lord.
Yes.
The petitioner as a wife of deceased Mozadar cannot be regarded as class 1 heir in the matter of appointment of Mozadar, unlike succession of properties of her husband. So this is, in my respectful submission, my lord, after the passing of the Hindu Succession Act, my lord, any devolution of heirship has to be done in consonance of the act, my lord. It may be property or it may be any other hereditary matter, my lord. Now, that factum that the Mozadar, appointment of the Mozadar is through a hereditary process has already been found place in a judgment, my lord, which I was trying to point to. And my lord, a cousin does not fall within the definition of family member. That has been decided in some other service matter, my lord, which I just got from the internet, my lord, of our High Court, my lord, in a WPC, my lord, in which the member of families were my lord, regarding preferential appointment rules, my lord, when you were interpreting, Honorable Court has held that family member, a cousin cannot be included in the definition of family member. Judgment, my lord, it is WPC number 4552 of 2022 and order dated 18/7/2022. My lord, here copy 9, no? Now, my lord, paragraph 11, my lord, of the affidavit. Of that affidavit of respondent number 1. There they have given reason why they have recommended for my lord 4. That the entire process of appointment was initiated and completed as per regulation 1886 and executive instruction framed under the same regulation, and no irregularity or illegality has been committed. Both the candidates are members of the family their main criteria is one is HSLC pass, one is HS pass. Even for the purpose of my lord holding the post of Mojadar, my lord, HSLC and HS, my lord, does not make much of a difference, my lord, here. Because the minimum qualification prescribed by the regulation is possessed. The vernacular medium, which I read earlier, my lord. Good knowledge of the vernacular medium. Another, my lord, argument was made, my lord, when this matter was in the admission state, that she is a lady, my lord. So they have more confidence on the, my lord. In my respectful submission, our president of our country is a lady.
This is the part.
No, my lord, no, but the submission was made. And so, my lord, this is my basic case, my lord. And if I may just take your lordship that there is a provision for appointment of Gaubura, my respectful submission, that will be argued, my lord. But that cannot be considered to be in perimeteria with, my lord, the appointment of Mojadar. Because Gaubura's provision under 160, it has other factors also, my lord. Here it is more clear, my lord. It has to be by inheritance. And that is my.
Yeah, for the private one. Yeah. And for the commissioner, who would like to hear you first, then we'll have go to the private response. Who has taken the decision? Decision making is whom? By the department or the deputy commissioner?
Ultimately, with the request of the commission.
That is the department. Yes, Mr. Doctor.
We have filed our affidavit in terms of order is 5/8/2022. Yes, our role is very limited. Let's see the order is 5/8/2022. 5/8/2022.
Yes, 5/8.
In in the meantime, respondent in the revenue department may file affidavit making a stand as to what is the meaning and purport of the expression family members of his family, that is members of the family of the immediately preceding this Mojadar. On the basis of this order, we have filed our affidavit. And our stand has been already petitioner council has already stated.
Yes.
Paragraph 5 produced page 37. Start from 36 and 11. Para is 7. The purport already has read it. That purport of the expression members of his family is to be gathered from the Assam Land and Revenue Regulation 1886. From the scheme of the Regulation 1886 and executive instructions, the Mojadar's duties are confined to collection of revenue and other government dues. The details of the duties to be performed by the Mojadar have been outlined in the Assam Land and Revenue Regulation 1886. That is the executive instruction 120, 121, 122. Para 8. It is relevant to state that two persons had applied for the post of Mojadar in Kampur Moja, Nagaon. On the one of the applicant named Hemanto Goswami, person number 4, the son of Hiranyo Goswami and grandson of late Krishna Goswami, is nephew of the deceased Satyendra Goswami. He is the third Mojadar. The other applicant, Srimati Dipi Goswami, is the wife of Satyendra Goswami. Family may ordinarily connote a group of people related by blood or by marriage. In that sense, Hemanto Goswami is related by blood, being nephew of the Satyendra Goswami, whereas Dipi Goswami is related to Satyendra Goswami by marriage, being wife of Satyendra Goswami. For this reason, both petitioners and person number 4 have claimed over the post of Mojadar. Since executive instruction has not defined the meaning of family, we have to find out the general meaning of the family. In that aspect, I want to place this meaning of family in black law dictionary. Next, 620. Family. 620 right hand side. A group consisting of parents and their children, also termed immediate family. 2. A group of persons connected by blood, by affinity, or by law. Okay. In this aspect, both the petitioner and respondent number 4 are family members. The executive instruction already says that being the if other qualifications are equal, then education qualification has to be looked at. In that aspect, person number 4 has higher qualification than the petitioner. So, on that perspective, he has been considered. Another aspect, petitioner council argued that succession, Hindu succession actually.
Yes, yes. On that part,
So, only see, this cannot be a. Sorry. Executive instruction 120. Mojara is a public servant. So, my respective solution is succession, Hindu successor could be not applicable in this perspective. Since it is a public service, post of work. When we have, on that aspect, we have made an statement in paragraph 10 or paragraph 10 of our. Paragraph 10 that the petitioner as wife of deceased Mojadar cannot be regarded as
page
40. 40. That the petitioner as the wife of deceased Mojadar cannot be regarded as class 1 here in the matter of appointment of Mojadar unlike succession of properties or of husband. The appointment of Mojadar has to be proceeded as provided in the regulation of 1886 and executive instruction framed thereafter under this state regulation. This is our step. The other 116 of executive instruction another section. Already he has read it.
Yes.
116 2 subparagraph. subject to such changes as may be required in order to give effect gradually to the foregoing principle, a Mozatar successor shall ordinarily be selected from the amongst members of the family, including relations on female side, if no qualified heir is available. In this provision, lordship only use word used only here. That is not defined as class 1 or class 2. In that aspect, if the general meaning is we have appreciate, we have then both of the family, both the petitioner number 1, petitioner and petitioner number 4 are family members. Look, other part government will respond.
Borough for district.
Yes.
In our affidavit, lordship,
File affidavit.
yes, by the respondent number 3, lordship. That's by one Santona Boral.
Number 3.
Respondent number 3.
File.
Yes, lordship.
Santana Pot, right?
Yes.
Filed on 20th of October.
Lordship. In paragraph number 4, lordship, we have categorically stated, lordship. First, lordship, it was noticed that between the petitioner and the respondent, they seem to be qualify all the criteria, lordship. But in respect of the qualification, lordship, that private respondent is possessing higher education qualification than the petitioner, lordship. And that is also specified in the executive instruction, lordship. 165. Being equal, preference shall be given to the candidates who have higher education qualification, as such as those connected by matriculation or higher passage. So basically, we have taken this stand. Lordship, so far as the family is concerned, lordship is understood that originally the Moza was run by the grandfather of the private respondent number 4. So ultimately, they come under the same family, lordship. It cannot be said that that they are outside the family, because it was originally run by the grandfather of the private respondent number 4. And because of the now, lordship, the stay order, now the circle officer of Kanpur Revenue Circle is running the lordship Moza. Whatever we have done, lordship, as per the executive instruction, lordship, it is specifically stated in cases of equal, lordship, that preference shall be given to the higher education qualification, those who are possessed. These are our, so far as that, lordship, S120 Mohadar is a public servant. So whether in such category, the application of the Succession Act will apply or not, that's also debatable.
Yes.
My humble sir.
The thing has been shown, my lord, page 43, your lordship can see, which is what is enclosed here along with the affidavit filed by the joint secretary.
Here for R4.
R4.
You want to for
Page 43.
43.
Yeah. That is the, my lord, position of the petitioner and the respondent number 4. It is given by the government, my lord. The lordship will kindly see
Krishna Chandra Goswami, has your lordship seen?
Yes,
Krishna Chandra Goswami, he has
this is
got
family,
three sons.
family tree.
Yeah, family tree, my lord. I am Hemanta Goswami, and the lead petitioner is DP Goswami. And only, my lord, both are qualified as a, my lord, member of the family. And what they say, my lord, that they are the heirs. Heir is, my lord, succession is a totally misplaced argument, I must say, my lord, because this is succession act, your lordship knows it relates to property. If I die, who will get my property? This is my lord, your lordship will kindly say the 3F. Heir means any person, male or female, who is entitled to succeed to the property of an intestate. So property, my lord. This is a totally misplaced argument, I must say, my lord, with all respect. And even section 8, it says, my lord, general rules of succession, the property of a male Hindu dying. Page section 8, your lordship will kindly see. The property of a male Hindu dying intestate shall devolve according to the provisions of this chapter. So the property. So this Hindu Succession Act is totally misplaced, I must say, my lord. My simple submission is that it is a misplaced submission, and this relates to succession of a property. Now the fact is, my lord, your lordship will kindly see that section. Your lordship has already gone, my lord. Section 116(5). It says, for the other things being equal, preference shall be given to candidates who have higher education quality. And the petitioner is about 61 years age, and I am about 40 years, 40 or 41 years. Petitioner is 61 years, I am 40 years. And your lordship will kindly see the duties of the Mojadar. Page Executive Instruction 123. From 121. 121 of the executive instruction is the duties of the Mojadar, special duties, and all the details are there. 121 executive instruction.
Yes, duties.
Yes. First is, my lord, my learned friend has already shown your lordship, the Mojadar is a public servant. Second is duties. In regard to the land revenue, the Mojadar's duty shall be confined to collections, and he shall have no concern with its assessment, the settlement of land, the checking of maps or assessment papers. The Mojadar, however, is responsible for reporting any systematic or extensive commissions. Then collections of house taxes, poll tax. Then collections of grazing fees and other duties. Then special duties to supervise the performance of their duties by Gau Buras and all those, my lord, special duties are there. Then Executive Instruction 125. The Mojadar shall generally act as a deputy commissioner's assistant in all administrative matters within his Moja, so far as he may be called upon to do so. But care must be taken not to impose upon him work which interferes with his primary duty of collecting the land revenue, and in particular not permit reference of cases of for inquiry to become a heavy tax upon his time. So therefore the duties are there. Now the authorities is to select who is the best qualified, who is the age one. They have selected me. Otherwise both are qualified, and they are to select whether HS or HSLC, whether 41 years or 61. So I find, my lord, there is nothing wrong in selecting the respondent number 4. He also falls under the family, my lord. This petitioner is also a member of the family. Your lordship will kindly see, I have given one central government notification. Next.
Regarding
regarding family one. They have not in details dealt with family, but central government. Next page, your lordship will kindly see. As per second paragraph, as per Rule 2 of the TCS Rule 1964, definitions of members of family may differ from that given in the Rule 2. Subclause C in the context of rule. For removal of doubts, it is clarified that in the context of Rule so and so, member of family in relation to a government servant include the wife or husband or son or daughter, parents, brothers or sisters, or any other person related to any of them by blood or marriage, whether they are dependent on the government servant or not. So this is the meaning of the family given by the central government in TCS rule. Government has not come forward the meaning of the family in the executive instructions or in other. But no doubt, my lord, he is a family member because his grandfather was a Gaubura, like a Mojadar. So after that, my lord, his father also have been the Mojadar, but because of different reasons, he could not become. So petitioner's husband has become. So thereafter, my lord, both are qualified as the government has said in their affidavit. So now they are to select on the basis of qualification and according to me also age. Therefore, I have humbly submit, my lord, there is nothing wrong in the selection of respondent number 4 as the Mojadar, particularly taking into consideration his age and quality. And the duties concerned.
There any
There is no retiring age, but they either because of sickness or they die. That is how
unless
they
no. Sir, Abha, we'll conclude the hearing.
Will be kept as CAB, my lord?
Yes. But we'll be delivering it earliest. No, sir. Could have done this today, but today we don't have any other. No. Sir, Abha, your counterpart there? Where? Can you call her? Or, I think her Senate Council or also her as the Senate Council cabinet as the first it does four. It, for junior is And Mr. Abha, probably private respondent some counsel.
He has left the
Anyone from the police?
private hospital. Here is the
But the judgment was written to the man. This petitioner not to that. The public is we have been given. Judgment is correct. It is
yes, ma'am. up part. It well when was for of various junior colleges of senior schools. To numbers of district of Dal, state district of Dal, there were 5 numbers, including of the Kolaigaon near because with the second was a common one, and therefore had named the name of particular he was to complete at least for 5
of the, if not for the entire number, because including the evaluation would also reveal that apart 5 numbers of comments, including the rest of 5, have checked for a month. There are many other persons who had got marks and the comments have not got. More solution reveals that apart from the following candidates has got either more marks or equivalent marks for the in a third. There are 3 candidates with 70 and 5 other candidates with equal. Under those circumstances, this court is of the view that even assuming that the case for interference is made out, no effective relief can be granted to the petitioner, as there are many other incumbents who have secured more marks and are not made parties than that has been noted by the exam. With regard to the allegation made in respect of 5, this court upon examination records has noted that there is an award by the petitioner and there cannot be said that marks given under the criteria. The marks under the state has been by the given to the respond for 5 months. So far as the marks allotted under the head of 10% is concerned, the fact that the ACR of the respond for 5, no grading by use of expression outstanding value could etc. have. However, the remark given is that he can be considered for next. Such a remark cannot be termed as worse or unfavorable. Further, an incumbent cannot be made to suffer any because of non-following of the procedure while with an SCR. Under those circumstances, cannot find fault on the part of the remark under the therefore it cannot matter this court, the Honorable Supreme Court, first opinion should not be interpreted. And this court shall consider can copy of the record.